All right, let's dive in. We're going to tackle a word that, let's be honest, can sound a little intimidating: contracts. But I want you to forget all about those dusty old legal books, because contracts aren't just for lawyers, not by a long shot. They're a huge, everyday part of all of our lives, and in ways you probably don't even realize.
So I'm going to ask you a question right off the bat. How many contracts have you actually made today? Now, your first thought is probably, zero? I haven't signed a single thing. But what if I told you the answer is almost certainly more than one? Maybe even a bunch more.
Okay, think about your morning. Did you grab a coffee? The moment you ordered, you formed a contract. Seriously, you made a promise to pay for it, and the coffee shop promised to give you that amazing caffeine boost. It's a simple exchange of promises. Or what about getting around? Hopping into a taxi or ordering a rideshare? Yep, that's another one. That simple act creates a little agreement on the spot. You're getting a ride, and you're promising to pay up when you get there. No signature, no fuss. And of course, in our digital world, this is happening all the time. You know that little I agree box you click without reading? I mean, we all do it. Well, every single time you do that, congratulations. You've just entered into a very real, legally binding contract. So it's pretty clear contracts are everywhere, popping up without us even thinking about it. But how do they actually become a thing? How are they officially born? Let's break down the main ways they're formed. Okay, the most obvious one is what we call an express contract. This is when all the terms are laid out super clearly, either in writing, like signing papers to sell your car, or even just spoken out loud. But as we've already seen, a ton of them are implied contracts. This is where your actions do all the talking. Ordering food at a restaurant, your actions imply you're going to pay that bill. Now, here's a really interesting one: the quasi-contract. And here's the thing, it's not actually a contract at all. Think of it more like a legal safety net the court creates to prevent things from getting unfair. Let's say a package you didn't order gets delivered to your door by mistake. You didn't agree to anything, right? But the law basically says, hey, you can't just keep that without paying, to make sure one person doesn't get unfairly enriched. It's all about fairness. And this, of course, brings us right back to the modern world with the e-contract. Remember that I agree button? Well, that's it. That's you creating a formal electronic contract. Every time you book a flight, download an app, or sign up for a new service online, you're making an e-contract. Okay, so we know how contracts get started, but here's the deal. Not all contracts are created equal. Some are strong and healthy, others not so much. So let's do what I like to call a contract health check to see if an agreement is actually legally fit. What we're always aiming for, the absolute goal, is a valid contract. This is the gold standard. It's a perfectly healthy agreement. Think of a standard lease or an employment contract. It checks all the legal boxes and is completely enforceable in court. No problems here. But sometimes things aren't so perfect. A voidable contract might look valid on the surface, but there's a serious problem under the hood. It gives one of the parties a legal out to cancel it. Why? Well, maybe they were forced into it, literally, like signing at gunpoint, or they were tricked by some kind of fraud. The key is the victim gets to decide whether to kill the contract or not. Then you've got the void contract. This one is basically a dud from the get-go. It has zero legal effect. It's like it was never even a real contract to begin with. It's unenforceable by anyone for any reason. It's just null. And a contract can be void in a couple of ways. First, it can be void ab initio. I know it's fancy Latin, but it just means void from the very beginning. A classic example is a contract to commit a crime. That's never going to be legal, right? Then there are contracts that become void ex post facto, which means after the fact. The contract was perfectly fine when it was made, but then something changed. Like you had a deal to import a certain product, but then the government suddenly bans it. Well, that contract is now impossible to fulfill, so it becomes void. And finally, we get into the nitty-gritty with the unenforceable contract. Now, this is a tricky one. The contract itself is actually valid. The agreement is solid. But there's some kind of technical defect that stops a court from enforcing it. It could be something small, like it's missing a special stamp it was supposed to have. Or a big one, like the time limit to sue over the issue has already passed. The deal was real, but you've lost your chance to get a court's help. Okay, let's do a super quick recap of that health check. You've got valid, good to go, fully enforceable. Voidable, one person has the choice to back out. Void, totally dead, no legal effect. And unenforceable, it's a real contract, but you can't take it to court because of a technicality. There's your full report card.
All right, so at the very heart of any contract is a promise, right? But how do those promises actually work? Is it a two-way street or a one-way street? Let's talk about the flow of those obligations.
So most of the contracts we deal with are bilateral. Think of it as a two-way street, a promise for a promise. I promise to pay you for the bike, and you promise to give me the bike. Simple. But then you have unilateral contracts, and these are more like a one-way street. It's a promise in exchange for an action. The classic example is a lost dog poster with a reward. The owner is promising money, but there's no contract with anyone until somebody actually finds and returns that dog. The action completes the deal.
Okay, we've covered how contracts are born, their legal health, and the way the promises flow. So what's the last piece of the puzzle? The final handshake. When can we officially say a contract is done? Well, when everything is all said and done, it's called an executed contract. This is the finish line. It means both sides have done exactly what they promised. The job is totally finished. The painter painted the house, and you paid them. The deal is closed, complete, executed. But of course, before you get to that finish line, the contract is in an executory state. This just means it's still in progress. The story isn't over yet. One, or maybe even both people still have things left to do. Like if you've ordered a new couch, but it hasn't been delivered yet, you're in an executory contract. The agreement is alive and kicking, it's just not finished yet. So there you have it, from your morning coffee to that I agree click. Contracts are really just the invisible architecture of our daily lives. They're not some scary legal thing. They're for all of us, every single day. So now that you know how to spot them everywhere, my question for you is, which of these everyday agreements are you going to look at just a little bit differently from now on?